Hello YouTube, I'm Vince White. I'm an employment attorney on this channel. We answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from AR American, who asks us, what if defense counsel ignores my lawyer's request completely for a mediation? That's normal. They don't have to mediate. That's certainly a tactic they might take. But the question goes on, typically what can happen in a status hearing coming in the next couple of months? Listen, a status hearing is going to be slightly different in different jurisdictions. Different courts, federal courts, state courts have different procedures, different rules, right? The federal rules of civil procedure set out fairly, clear expectations, but state courts vary wildly, and even federal courts vary to some extent, and different judges, different magistrates will have different expectations of a status conference. Essentially, a status conference in litigation, just speaking so generally, not giving you any legal advice wherever you might be to expect anything, because I don't know where you are, and I wouldn't be allowed to speak to the laws of the jurisdiction you're in, most likely. So check with local counsel. But generally speaking, a status conference is going to look at the various things coming up in your case. How are the deadlines being respected? Are the judge's scheduling orders being complied with? How's discovery going? Do we have any dispositive motions, like a motion to dismiss or a summary judgment motion coming up? Do we need to have depositions scheduled? How is that going, right? How are parties working together on the litigation? Which seems strange, but plaintiff's counsel and defense counsel have to collaborate on some things, right? They've got to comply with various orders together. They've got to potentially bang out scheduling orders, or at least propose scheduling orders for the judge's chambers to approve or deny or change or ignore completely. So all of these things could be happening at a status conference. I don't know where in the process your case is, right? So I don't know what your status conference will be dealing with, right? If your case is just fresh off an answer and the other side just declined mediation, then there's a decent chance that your status conference will deal with potentially asking for leave to make a motion to dismiss from the defendant's side, potentially, right? That's often something that happens, or setting a discovery schedule for interrogatories and document discovery and depositions, and when things should be turned over by, and forensic, all these things, right? Electronic discovery, everything. So that might be what's going on. If you're past discovery, or if you're in the middle of discovery, you might be talking about like, hey, we've got some motions to compel disclosure going on. All right, we want the documents. They're not turning over. That the status conference could be dealing with that. You could be dealing with, well, listen, we got 3 depositions scheduled, but we got 10 more that are not scheduled, and the other side won't give me dates. They can deal with that, right? If discovery's over, you might be looking at like, well, we've got to set out some dates for summary judgment motion, potentially. There might be one here. When is it to be made by? When is it to be opposed by? Is there like a reply brief, right? Or even setting out trial dates. All fair game for status conferences, right? So, AR American, I hope this helps. If it does, like, subscribe, comment down below, share the channel so it can grow. Good luck to you.